On March 27, 2025, President Trump signed an executive order to exclude numerous federal agencies from the provisions of the Federal Service Labor Management Relations Statute. This action effectively stripped collective bargaining rights from a significant portion of the unionized federal workforce, with some estimates reaching over 1 million workers. The order, which was later expanded on August 28, 2025, terminated existing collective bargaining agreements, CBAs, and prohibited the negotiation of new ones for employees in a wide range of departments and agencies, including parts of the Department of Veterans Affairs, NASA, and the National Weather Service. This move sparked immediate and fierce opposition from federal employee unions, who viewed it as an unprecedented attack on their rights and a direct act of retaliation. Analysis, reasons, and consequences. The administration's stated rationale for the executive order centers on national security and efficiency. Citing a provision of the 1978 Civil Service Reform Act, the White House argued that collective bargaining processes are a hindrance to a responsive and accountable civil service, and can delay the swift implementation of policies vital to national security and critical missions. Officials have also accused unions of rewarding bad employees for misconduct and obstructing the administration's agenda through legal challenges and grievances. This perspective frames the executive order as a necessary measure to streamline government operations and ensure that agencies can act without being impeded by what they see as bureaucratic union processes. From the perspective of labor unions, however, the executive order is a pretext for union busting and a punitive measure against organizations that have publicly opposed and challenged the administration's policies. Unions, including the American Federation of Government Employees, AFGE, have argued that the invocation of national security is a disingenuous smokescreen. They point to the fact that many of the targeted employees, such as those at the Patent and Trademark Office or the National Weather Service, do not have roles that are directly tied to national security in a traditional sense. The consequences of this order for federal workers are far-reaching. Without the protections of a CBA, employees lose crucial safeguards for whistleblower protections, due process and disciplinary actions, and the ability to collectively negotiate for better working conditions, pay, and benefits. The termination of grievance proceedings and the shortening of performance improvement periods to as little as 30 days also make it significantly easier for management to discipline or fire employees. Predictions and solutions. The future of this issue is highly likely to be decided in the courts. Federal unions have already filed lawsuits, arguing that the executive order is an unconstitutional act of retaliation. While a federal appeals court initially lifted a block on the order, the Ninth Circuit Court of Appeals has since signaled it will reconsider the decision. This back-and-forth legal battle is expected to be a long and protracted affair, potentially reaching the Supreme Court. The administration's move to terminate contracts even while litigation is ongoing suggests a desire to establish a new precedent quickly, forcing the unions into a defensive posture. In addition to legal action, political and legislative solutions are being pursued. Congressional Democrats, such as Congressman Jonathan Jackson, have openly denounced the order and pledged to work with union partners to fight it. While the specific legislative response, such as a bill to restore collective bargaining rights, may face an uphill battle in a divided Congress, it demonstrates the issue's political saliency. Public and political pressure will also be a key factor. By framing the order as an attack on the very workers this holiday is meant to honor on Labor Day, unions and their allies aim to garner public support and rally opposition against the administration's actions. The ultimate solution may be a combination of these efforts: a definitive legal ruling, new legislation, or a change in administration policy based on sustained political pressure.